Okay, we are live.
Thank you, Mr. Ewert. Good morning, folks who are joining as we've gone live. I hope everyone can hear me and see me. My name is Ruben Duran. I have the honor and privilege of being the chair of the State Bar's Ad Hoc Commission on the Discipline System. It is just about 9 o'clock, the appointed hour to call the meeting to order. If I'm not mistaken, this is the first time we have gathered collectively as a large group in some time. And so it is certainly nice to see everyone's names and faces. I know that folks have been working hard in the interstitial period between our last meeting and this, and so I look forward to hearing all of the good work that folks have been doing. I will offer my thanks in advance for that good work. At this point, we will call for public comment. This is a portion of the meeting where members of the public may address the commission on any item of interest for the commission's consideration. Certainly we encourage and welcome such input, and if I'm not mistaken, we've heard that there might be some folks who will be joining us, and so I will turn the table, as it were, to Mr. Ewert to facilitate that. And
first, we're going to call the roll for the meeting to order.
That would be important. Thank you, sir.
I'm going to call the roll, and I can't quite see everybody yet, but if you're here, please say so.
Justin, can I just say, can you admit Martin Winfield, please?
Yes, and I will. I have admitted him. Okay, the roll. Michelle Anderson. Don't see. Karen Bell.
Here.
Ray Buenaventura. Shanae Buffington.
Present, thank you.
Sharon Ershadi. I think she was going to be late. Gary Farwell.
Here.
Sarah Good.
Here.
Jenna Jones said she was going to be late. Shalon Joseph said she was going to be late. Janet King.
Here. Thank you.
Jerry Larkin.
Here.
Melanie Lawrence. Ed Lear.
Here.
Alexia Mayorga. Thought I saw. Hi, Alexia.
Good morning.
See you're here.
Sorry, my computer just crashed.
Okay. Judge McGill.
Here.
Steve Moab.
Here.
Cynthia Nakau.
Here.
Ellen Pansky.
Here.
Eloise Rosenblatt.
Here.
Linda Schneider.
Here.
Sean Salig.
Here.
Brandon Stallings. I don't see. Judge Wang.
Good morning.
And Martin Winfield.
Here.
All right, we have a quorum. Now, if there is anyone in the public that would like to make public comment, if they could please raise their hand. There should be a little button. I don't see anyone. There's only one person of the public and they don't have their hand raised at this time.
Okay. With that, I will move to item number one, which is the chair's welcome, which I sort of started already. For those of you who've joined us since we have called to order, good morning and welcome. Thank you for your attendance today. Thank you for the work that you've been doing on these important issues through the subcommittees. This is the full commission meeting today to go over 3 items on our business agenda, but each of those items certainly has subparts that are, I think, going to be meaty and should present some interesting opportunities for discussion and hopefully moving the work of the commission forward. Mr. Ewert, I know that you prepared a PowerPoint slide. While you're getting that up, before you get that up, I'd like to inform the commission that since our last meeting, the Board of Trustees has authorized the appointment of 2 additional members to our group, and I'm very excited and grateful that one of them is here so far, and then I understand the second will be joining us late. These 2 members represent public interests, in other words, consumers of legal affairs, a different perspective that I think many of us have talked about in some of our conversations at the subcommittees. And so we've wanted to give that voice an official place here at our meeting. We look forward to having Ms. Janet King and second member Sharon, and I'm blanking on her last name. Justin, help me out.
Rashade.
Rashadi, thank you. When she joins us, I will acknowledge her and ask her to what I'm about to ask Ms. King to do, which would be if Ms. King, if you would just offer us a brief introduction, anything you're comfortable and willing to share, and we're very glad that you've joined us this morning.
Okay, thank you for having me. My background professionally is I've had different businesses. I've authored children's workbooks. I've sold real estate. Legally, my background only is related to a divorce. I've worked with different attorneys and I've self-represented, but I look forward to giving my input from not having the background that you guys all have. So thank you for having me.
Thank you again. We look forward to working with you. Mr. Ewart, if you want to put up the slide, that'd be great.
Sure. And so we can go to the agenda slide, the next slide.
Great. And this is certainly just what you've already seen on the posted agenda. And as I mentioned, they're pretty broad topics. We do want to hear from the chairs of the 2 subcommittees, Effectiveness and Fairness, Ms. Buffington and Mr. Lear. And then we'll move over to an update on the creation of working groups, an update on the working groups that have been established and have been working, and then to see whether we need to or want to create additional working groups for specific topics. And then we'll wind up the day with a discussion of what comes next for the larger commission and perhaps even for the subcommittees and the working groups. We are scheduled to go until 1 p.m. Today, which I assume means that we may take a short food break if it looks like we're going to use the full 5 hours. Certainly feel free to turn off your video and take care of business if you need to step away for personal bathroom time or whatever. Before I start, are there any questions from any of the commission members about the agenda? If not, then we will hand it over to the Effectiveness Subcommittee to handle the first report. Okay, I don't see any questions.
Okay, and the next slide just talks about the goals of this meeting. And so the goals for today's meeting is just to review what has been done by each subcommittee and validate the focus areas. So there have been working groups that have been formed, and then there have been decisions made where working groups were not formed. And so we're just validating as the full ad hoc commission those decisions that were made by each subcommittee. And then of the working groups, later on, there is probably one more that needs to be created of the full ad hoc commission. Maybe there's more throughout our discussion today. And so I will also be taking volunteers for, even if a working group has already been created, we could still use some volunteers to join these working groups, because this is where the work is going to be done between now and next June 22nd, when we have the full report due. So with that brief introduction for the goals of today's, I will turn it over. This is the timeline that I've shared with both subcommittees, so this should be quite familiar. Today we're meeting as a full ad hoc commission. For the next 5 or 6 months, we will have the working group meetings. As we get those recommendations finalized, we will bring them back to the full ad hoc commission, and then we will make presentations on these recommendations so the full ad hoc commission can decide whether or not they want to be a part of the final report. and recommendations that are to the Board of Trustees. And that adoption of the recommendations will be in late May or early June because the report is due to the Board of Trustees in June of 2022. The next slide, I think, jumps into the Effectiveness Subcommittee. So Ed Lear was our chair for the Effectiveness Subcommittee, and he's going to help guide us through these next couple of slides to update the commission on what was discussed over in effectiveness. And I don't know if you have any opening remarks, Ed, or anything.
I do. So good morning, everyone. Nice to see everybody. The Effectiveness Committee has been working very hard. We've had some very nice dialogue amongst us in the meetings, and I have learned a lot, and I hope everyone else on the committee has learned a lot. And the goal out of the summary today is to distill what we have learned and to impart that knowledge upon the rest of you, so you have an idea as to what we've done, what conclusions we've made, and what conclusions still need to be made. So with that, I'll turn it back to Justin, who will be speaking about the state audit.
So the Effectiveness Subcommittee, the California State Auditor audits the State Bar every 2 years, and the most recent audit came about in April of 2021, and it focused on the Office of Chief Trial Counsel. And since our charter is to review all the changes that have been implemented through the Office of Chief Trial Counsel since 2016, the decision was made that it would make sense to review the state audit. And the state auditor had several recommendations for the Office of Chief Trial Counsel, a lot surrounding the backlog. And so the backlog measure, all cases over 180 days, was talked about and presented to the subcommittee. There was also the state auditor talked about staffing adjustments and what would be needed and potential proposals. So they gave 8 recommendations that the Office of Chief Trial Counsel and the State Bar in general need to review and report back to the California State Auditor on the progress of implementing those recommendations and reviewing those recommendations. The Effectiveness Subcommittee was presented on backlog, had information presented on alternative to backlog, and really just got an overview of the state audit. The decision was made that there wasn't necessarily a working group needed because the State Bar was actively implementing this review, and that once this review was done, because a lot of this review, there's going to be a workload study and other things will be completed prior to the end of this commission. And so we could bring this back to the full ad hoc commission as things are implemented of the recommendations of the audit, but there wasn't a need for necessarily a working group since the work is already being done. And so that was the decision on the state audit. It was more of an informational thing presented to the Effectiveness Subcommittee. Are there any questions on the state audit?
Mr. Ewert, I don't have any questions, but if I could just offer some remarks sort of from the perspective of the board with respect to the state audit. I mean, I think you've described it very well, the biannual process that we go through. And there is some back and forth with the auditor's office of the state. And as a board member, I certainly appreciate the important role that the state has in helping us examine and improve our systems for discipline. Sometimes we don't always necessarily 100% agree with their characterizations of our Chief Trial Counsel's office and our regulatory system, but we certainly appreciate the opportunity to refine and improve our internal systems in furthering our public protection mission. The improvements that are impending for the case processing system are a good example of the ways that we can and will continue to better the regulatory system and service to the public. And I think the commission probably knows and has seen the news that the board has selected a new Chief Trial Counsel who will be coming on board next month, I believe, very shortly. And so we look forward to working with him and all the folks in the Chief Trial Counsel's office to address the issues in the audit and to implement some of the work that we're doing here in the commission. So Let me just say that. I see Ms. Rosenblatt has her hand up.
Yes, my one question, either Justin or Ruben, is when you talk about the state auditor, and we had so many wonderful presentations our first couple of meetings about the reports and the reviews and the recommendations by the state auditor. How many people are we talking about? Is this a team or is it one person?
So the state auditor's office is a large arm of the state government, relatively speaking. I'm going to hand it over to Leah or Justin to give us some of the details about how many people are assigned to the state bar or have been traditionally.
Yeah.
Go ahead, Leah.
Oh, I would just say that it's typically a team, and the team can comprise anywhere between 5 to maybe 8 or 9 people is the biggest I've seen. And they're not usually comprised of the same individuals on successive audits, which can be a challenge for us because of the learning curves of, experienced by new team members. Justin, do you have anything to add, or have you seen a bigger team than that?
No, that's about what the team normally consists of.
Right.
Thank you for the question, Eloise. Any other questions on the state audit? All right.
Okay, we can go to the next slide. We talked about case processing in the Effectiveness Subcommittee, and we had a presentation from one of our Office of Chief Trial Counsels with an emphasis on consistency and calibration, how the Office of Chief Trial Counsel ensures consistency and calibration. And they talked about how they have regular team meetings and management meetings. They have calibration meetings on a biweekly basis. There are lots of trainings. They talked about MCLE trainings, brown bag lunch trainings, that new staff has a whole training component. There's a training team that brings the staff in, and there is some mentoring that goes on. There's also audits. So we send it out to an outside auditor who comes in and has findings, and that is used to train the different chief trial counsels. And so there was that presentation was also followed by ADDC, gave their perspective on their experiencing of the training. And a lot of this area was informational. There was discussions on it. There was a recommendation specific in the audit that talked about the state bar should implement methods to monitor its enforcement process performance, including trial counsel staff performance to benchmarks. And so this is one of the areas where it's contained in the California state audit. And so it was another area that as the state bar furthers these recommendations, implementing these recommendations, that this could be brought back to the committee, and that there wasn't necessarily an area where the committee needed to develop a working group to delve down into these, because measures and metrics were being developed at the time. And so that is kind of the overview of the case processing. When we were talking about this, there was some talk about progressive discipline. And this is an area where I will address it later, because I think that both subcommittees have talked about having a progressive discipline working group, because it impacts effectiveness and it impacts fairness. And I will be soliciting volunteers for that working group later on in the meeting today. So I don't know, Steve, if you have anything to add, or if I kind of covered, or Ellen or Ed, if you have anything to add on the ADDC side.
I have nothing to add, thank you.
Okay. These were the two, to lead it off, they were more informational. I didn't necessarily anticipate working groups being developed, but now we will go and switch into the meatier topics. If we go forward to the next, if there are no more questions on case processing, we'll shift forward to factors that impact case settlement. And this was a lengthy area of discussion. There was lots of discussion. There were 3 main focus areas that we talked about settlement, and they were the Early Neutral Evaluation Conference, the ENEC, stipulations, and the charge of moral turpitude. And these three areas were extensively discussed, and eventually some working groups were made up. So I don't know, Ed, if you would want to talk about
Yes.
these different areas and give your perspective.
Yes, I will jump in. So, and Justin is absolutely correct. We've spent a lot of time speaking about this, and this, I think, goes to the heart of effectiveness insofar as how good is the system working in terms of accomplishing the goals of public protection and integrity for professionals. And so I'll backtrack just a little bit for the purposes of the fairness group members. The ENEC is an acronym for Early Neutral Evaluation Conference, and it is a defense lawyer's best friend. So in that regard, it's a settlement conference with a state bar court judge that is pre-filing. And it's something that every respondent is entitled to in every context except for criminal convictions. And we'll get to that in a moment. But it's a situation where the OCTC and the respondent have an opportunity to hear from a judge who will not be the trial judge as to what the judge's early neutral evaluation is. And the point of that is to try to get a settlement at a very early stage. The advantages of getting a settlement at an early stage are, one, dramatically reduces the costs, both in terms of the grid, the cost grid that the state bar uses to require costs where there is any kind of public discipline, and also dramatically reduces the cost that a respondent would pay to defense counsel in representation through the litigation process. The other part that is really critical and important to respondents in particular is that it gives an opportunity to negotiate for a private approval. And by that, I distinguish that from a private approval that is a settlement after the filing of a notice of disciplinary charges. And in that situation, a private approval would be one with public disclosure and would be on the member's record for the rest of the member's career. And so you can imagine that my clients are very motivated to have an opportunity to have a private approval through an ENEC process, as opposed to having a private approval that's negotiated after the initiation of charges through a notice of disciplinary charges. Where I brought this up, and I tend to be the one that rants the most about this particular thing, is that because of the fingerprinting cases, there were an awful lot of old DUIs. And those were situations where many times that the most appropriate discipline would be a private approval. And in the way that things are set up now, a private approval of a criminal conviction referral would be a public private approval. And so part of what we've discussed and part of what our working group is focusing on is how to create a situation where criminal conviction matters those respondents could participate in an early neutral evaluation before the criminal conviction referral. What we have learned is that we collectively would need a change in through the legislation. And what I've learned as well, that it's not as easy as I had hoped it would be, because if we go the legislative route, then my understanding is that the recommendation of the working group would go to, I suppose, the Effectiveness Subcommittee, and then ultimately to full committee, and then to the Board of Trustees. And only after the group collectively puts together all of its recommendations at the end is when it gets presented to the Board of Trustees, which then decides which of those recommendations it will adopt and or recommend that its lobbyists pitch to the legislature. So it's a harder process than I thought, and I wanted to educate you all about that, because while I was familiar with maybe some of it, I wasn't familiar with all of it. And in particular, what I didn't know is that the ask to the legislature is a one-time ask. So that at least the protocol, as I understand it, is we won't be going to the legislature 15 different times with 15 different recommendations. And so that's a bit of the background that I have learned through the working group process, which was helpful for me to learn. We still are meeting as a working group. We still do not have a recommendation with respect to ENECs. We are exploring different ways where potentially we would not have to go through the legislative process. And Judge Wang had some angles on that we're continuing to look at, where, for instance, potentially we could lengthen the process while the OCTC is reviewing the criminal conviction prior to transmitting it to the state bar court, because as I've understood for a long time, once it's transmitted to the state bar court as a pleading, at that point it becomes public and there's no way to undo that. So that's the ENEC group that's working on that. We had a meeting recently where the bar put together metrics for us, which I thought were very insightful in terms of how many of these criminal conviction referrals actually end up in private approvals. What's the universe for which we're trying to create this change? And I for one was surprised that it's not very big. And at least by one metric, it may be that there are roughly 3 or 4 criminal convictions per year that end up as private approvals. Judge Wang pointed out that's a little, that statistic by itself in a vacuum is not the whole story, because as she knows, and I know, and some of the others on this call know, as a result of the fingerprinting cases of the last couple of years, many of those have resulted in dismissals. And the ENEC process for those would have been really advantageous, because at least the dismissals that I've achieved typically come after the transmittal is done and after significant legal fees have been paid by my clients. So it's something we're continuing to explore, but I remain positive and optimistic that we'll get a solution that we'll be able to propose to the group. We have also been working on moral turpitude charges and looking at moral turpitude charges and the impact on settlements. And in that regard, we've also formed a working group, and I will toss the baton to Ellen. Glad Ellen can join us. And Steve, you will also get a chance. So why don't we go to Ellen first?
Thank you very much, Ed. Good morning, everybody. So the Moral Turpitude Working Group has begun its work. We have a ways to go. The staff has been very helpful in starting to compile some statistics. We don't have a full picture yet, but let me digress for a moment and provide some background. The concept of moral turpitude is something that the non-lawyer members of the committee may not be familiar with. When a lawyer is charged with a disciplinary offense, typically the state bar prosecutor's office is going to charge a number of violations. It's very unusual that there would be only a 1 count or even a 2 count notice of disciplinary charges. Among the charges, in addition to the substantive violation of a rule or a statute, is a charge that the conduct involved moral turpitude. And the definition of moral turpitude is something that, frankly, the defense bar and the state bar prosecutor's office don't necessarily always agree upon. And there is an analysis that goes to whether or not the lawyer acted grossly negligently. And if the lawyer did act grossly negligently, then a moral turpitude charge may be sustained. The significance of this is that moral turpitude lifts the floor of discipline. So if the lawyer is found to have engaged not only in the violation itself, but also to have acted with moral turpitude, then the discipline is going to be higher under the standards. There are standards that the court uses as a guideline to impose discipline. So it can be quite significant whether or not the lawyer is being told, if you want to resolve this matter by settlement without going to trial, then you must also stipulate that your conduct involved moral turpitude. Needless to say that the label of moral turpitude sounds serious, and it is serious. And again, for the benefit of those who may not be familiar with the disciplinary system, when a lawyer receives discipline, either by agreeing to accept it or by going to a hearing and having the discipline imposed on the lawyer, if it's a public degree of discipline imposed after the notice of disciplinary charges has been filed, then it remains on the lawyer's record forever. And the concern is that now, particularly with the ease of doing internet research, any prospective client, any prospective employer, any commission such as this or a bar association will look up the lawyer's background. And if they see that the lawyer has been disciplined for a violation that involves moral turpitude, for a lot of lawyers, that's the kiss of death. And it means they won't get the client, they won't get the appointment, they won't get a judgeship, they may not get hired by an employer. So it is highly significant. So what we're trying to figure out is, what is the extent to which moral turpitude is added to other disciplinary charges? What is the extent to which the lawyers end up having a disciplinary disposition that includes moral turpitude? Is it after hearing? Is it by settlement? Is the lawyer represented? Generally, the statistics show that when a lawyer is represented in a state bar case, they get a lesser degree of discipline or a better result. And so this issue goes hand in hand with the state bar's examination of how to increase the level of representation for lawyers. We don't know yet, but it seems to me that there's a crossover issue here to be explored by the Effectiveness Subcommittee and the Fairness Subcommittee, because those lawyers who are disproportionately, well, let me say it a different way. When lawyers of color are disproportionately disciplined at a higher level, the question arises, are they represented? It's my suspicion that they're probably represented at a much lower level. So it seems to me there is a crossover, or possibly it's a crossover to these issues: representation, disposition, and whether that lawyer is being told you will not get a disposition unless you stipulate to moral turpitude, or you can go to trial. A lot of these lawyers don't have the resources to go to trial. It will take them out of their practice for a disproportionate amount of time. They don't really have the opportunity to become familiar with the unique rules that apply in a state bar disciplinary case, and they can't afford a lawyer who does know the system and is able to navigate it. So we have more work to do in this area, but I would say that's a summary of where we are at this point.
Thank you, Ellen. Steve, can you chime in?
Sure, thank you. I appreciate the opportunity. I don't want it to be sort of a point counterpoint. So let me start by validating, everything that Ed and Ellen just said. I mean, I think that what they have said are absolutely valid concerns. I do think it's important to keep in mind in both the moral turpitude and the E&EC arena that there is sort of an inherent tension between some of the things that they have mentioned, and there are some other concerns. So let's start with the E&ECs. I would say, as I mentioned, the inherent tension between that the working group is going to have to try to figure out the best way through. On the one hand, you have the respondent and legitimate concerns on the part of the respondent: damage to their reputation by the filing of a public document, increased costs if the case doesn't resolve pre-filing. As Ed said, those costs are both within the state bar costs as well as defense costs. And I don't want to diminish any of those very real impacts. We also have to acknowledge that the state bar is judged on our ability to protect the public. And this is often revealed in two different ways. Number one is the backlog statistic. Anything that delays our filing of an NDC impacts our backlog, and it is used frequently in criticism of the state bar as ineffective. Further, a delay in filing means that the public doesn't know about the nature of allegations that an attorney may be facing, whether that be a C case based on a criminal conviction matter, or a case that originates in the state bar based on attorney misconduct. There's a very real concern that the delay means that they could be out victimizing other people because of the confidential nature of the process, and because potential clients aren't aware. So it's the flip side of the very coin that Ellen mentioned. And I'm not in any way diminishing the concerns that she mentioned. There is a flip side of that, however. This means that anything that adds more time to our ability to get cases filed impacts public protection in regard to both the specific attorney and the system as a whole. And that does not mean that we can't figure out a way to improve the E&EC system. I think we can. But I think that there are still some questions that need to be answered regarding the effectiveness of the E&EC process. I do think that we all have theories about how effective it is, but we haven't yet seen evidence to support those theories either way, frankly. My understanding is that Oriya is working on that research, and I think that that is important. And I'm eager to see what the results of that research is. As for the specific E&ECs around the C cases, the conviction monitoring cases, as Ed said, prior to the fingerprinting project, we didn't have a lot of these cases. We had some. We had probably about 250 in a given year. That level increased tenfold with the fingerprinting when all attorneys in the state got re-fingerprinted a couple of years ago. And there were a number of cases that we discovered that we did not know prior to that. As Ed mentioned, in 2015, we had 3 respondents who had a conviction transmitted and then later had a case resolved for a private reproval. And obviously, again, I don't want to downplay the significance of the impact of these individual attorneys. They got a private reproval with public notification, right? It is out there in the public that they got a private reproval. That is significant. We need to try to reconcile that. So when we discussed, as Ed pointed out in the working group, Judge Wang made the very valid point that it's really even greater than that, though. It's not just those 3, as Ed mentioned. There's also situations where people will resolve a case for a public reproval because they figure it's already out there anyway. And again, as Judge Wang pointed out, there are cases where cases are being dismissed that after they're being filed. I would point out, as I did during that meeting, however, that frequently those are the fingerprinting cases where we have information based on that original batch of re-fingerprinting, what we're referring to as CORI cases or criminal offender record information cases. Those cases tend to be very old because it's the first time we're hearing about it. The only way we heard about it was because the attorney got re-fingerprinted and the Department of Justice sent us their records. And so that case may be 10, 20, 30 years old. And if it is a crime that is something that may amount to moral turpitude based on the facts and circumstances of the way in which it was committed or other conduct warranting discipline, then we are obligated to transmit that conviction within 30 days of getting evidence that conviction is final. Oftentimes, we do not have, at the time that we make the transmittal, because of the timing, the ability to get the police reports and the other information necessary to determine the facts and circumstances of the crime. And so we end up transmitting, and then by the time we figure out there are no records or the records don't establish the facts and circumstances that would be needed to demonstrate moral turpitude, et cetera, then at that point, the case is dismissed. And Ed's right, that happens, and there's a cost to that respondent, and that is unfortunate. That is a result, I believe, of the statutory structure in which we work at this point. I also expect that the number of cases that meet that criteria will diminish over the next year, year and a half as we work through those old cases. And in the future, my expectation is that we will not have 30-year-old cases because we will know about all of those since they were discovered at the time, we will only have relatively fresh cases because now the Department of Justice is sending us new arrests and convictions based on subsequent arrest notification contracts that we have with the Department of Justice. So we won't run into this issue again. The hope is it's a finite problem. I do have some discussion of moral turpitude, but I see that there's a hand up, so I'll pause.
Yeah, Mr. Roy, this is Shanae Buffington. I have a quick question. You just provided some information on how criminal convictions are transmitted to the state bar. How often does the Department of Justice, per your MOU, transmit those convictions to the state bar? And I'm asking because we had a member of our subcommittee, Mr. Martin Winfield. He had wanted some data on felony complaints as it relates to the discipline system. And Mr. Yearwood, I don't think we ever got around to discussing that information during our subcommittee meeting, and maybe Mr. Winfield can kind of flesh out more, what he wanted to see data wise. But I just wanted to bring it up. I don't want it to slip through the crack.
Trying to think what I was thinking.
You don't remember?
I remember, but I'm trying. And we were in depth, and I'm trying to think exactly where I was going. I just know generally, I kind of wanted to see the data of what type of convictions resulted in what type of discipline, and a comparison of who gets what discipline depending on, you see what I mean? Depending on what type of crime that is. Go with felony, misdemeanor, assault and battery, DUI, what are we looking at? And, how is that broken down?
I don't have that information. I assume that's something that Oriya could come up with. I see Lisa Chavez nodding her head. So hopefully that's a yes to my, my query.
I believe Lisa or Justin that Mr. Winfield's request has been annotated and is part of the research initiative for this commission, meaning Oriya is planning to pull that data together. And you are clear about what the request is.
Yes.
Yeah, and it came out of the expungement working group. I think we were talking about things, and I think that it was initiated by the consumer alerts, that there's a consumer alert when we're notified there's a felony arrest, and there was some generation of, and I think, Steve, you provided me an answer on that, it's just the arrest, and the consumer alert went up there. And I think Mr. Winfield asked how many times the people were actually not convicted of that information. And then there was also the other information that Mr. Winfield talked about. But yes, we are researching that information as part of the expungement working group.
Just one clarification. The consumer alert is not placed just upon an arrest. It is based upon the filing of felony criminal charges in Superior Court. And so there was some concern about the number of consumer alerts that were posted and then the charges dismissed. My recollection is that there were 3, I could be wrong, I could be off by 1 or 2, was that there were 3, but in all 3 of those instances, the charges were then refiled and the alert was placed back up.
So in response to the first question about the timing of the DOJ hit data, maybe Lisa, you can respond to that. My understanding is it's on a flow basis. I believe Liz said.
Yes, actually, can I ask Doug? Doug, can you just chime in, please, on that, on how often we get those, the information from DOJ?
Yes, it is on a flow basis. So those are processed by the Department of Justice. It's an automated processing system that has a matching of the fingerprints that they have on record as belonging to licensed attorneys in California. If they get a report, so the reporting starts from the county level. When the report of the conviction goes to DOJ from the county, then DOJ has a matching process where they match against the records that they have for our licensees, and then that is sent as an automated report to the state bar.
Thank you, Doug. I see Janet King has her hand up.
Yes, I had a question. I think it was best to be directed to Mr. Lear. as far as the ENC goes, are there any studies that show the success and not success on the ENC?
That's a really good question, and that's something we've asked for in terms of the metrics. So we are continuing to meet the working group for the ENECs meets every 2 weeks, and so we'll be meeting and getting metrics like that. But I open that up to everyone else. If there are metrics that you can think of for any of the topics that we're talking about that perhaps we have not thought about, then please raise your hand and let us know, because the bar has been fantastic in terms of assigning people and giving us statistics that we could work from to better inform us. Steve, did you have any other comments?
I did on moral turpitude, briefly, thank you. So again, here, I think this is a good example of how people have a perception of how a system operates, and we may even have anecdotes to support it one way or another, but we don't really have a clear picture of the whole story at this point, or at least at the beginning of this process. Oriya did do an analysis of 442 original matters based on 670 cases. We sometimes consolidate cases together and in OCTC and then file them as one matter in state bar court. And so those 670 cases, 442 matters, represented 429 respondents. And those matters all reached disposition in state bar court in the hearing department between March 1st, 2019 and May 31st, 2021. And Oriya found that 37% of cases that reached disposition in state bar court during that time had at least one moral turpitude charge. They also found that nearly half of all matters, not just the ones with moral turpitude, all matters are disposed of by stipulation, 1/3 by trial, and 1 in 5 disposed of by default. They found that the stipulation, trial, and default rates for matters with moral turpitude charges were not significantly different from the rates of matters without moral turpitude. So in essence, they found that the moral turpitude charge has no effect on the rate of disposition for cases. They found that the state bar court dismissed 1.4% of all matters for lack of merit. So the entire case was dismissed in 1.4% of those cases. While this dismissal rate for matters with a moral turpitude charge was actually lower, it wasn't statistically different than the dismissal rate of matters without a moral turpitude charge. That's what Oriya found. And then when looking at whether the moral turpitude charge itself, as opposed to the entire case, is dismissed at a higher rate, they found that the state bar court found 92.7% of respondents charged with moral turpitude were culpable of at least one moral turpitude charge. So the court dismissed moral turpitude charges, all moral turpitude charges, or the one if there was only one, but recommended discipline for non-moral turpitude charges in only 6.7% of matters where moral turpitude was charged. So again, that doesn't diminish in any way what Ellen said, which I think is very true, that, for example, the defense bar and OCTC may have a different understanding of where the line is that constitutes moral turpitude. But there was some talk about, overcharging and OCTC drastically overcharging moral turpitude. And I think that what the Oriya study found was that probably isn't the case, at least not to that extreme. Again, doesn't mean we can't make refinements and that ADDC and OCTC can't come together to try to wrap our heads around where some of the pressure points and problem points are. But I don't think that there is some extreme overcharging on the part of OCTC.
Okay, thank you. Thank you, Steve. Judge Wang, would you like to chime in?
Yes, I do, actually. Thank you, Ed. So I don't want to go into the rabbit hole, but in terms of, I'm going to go back to the conviction referrals and ENECs. Well, I made this point in the subcommittee meetings that when you're looking at a data point that shows well, you can interpret data any way you want, frankly, we've learned that through the politics here. But when we're looking at ENECs and public filings, and we're looking at effectiveness overall of the health of the system, when you have conviction matters that are filed immediately as a public matter, that impacts the court's calendar. So I know we're not talking about the efficiency of the state bar court, but I think we hit our numbers pretty well in the 80s and 90s, mostly the 90s recently. But we have a measure 3. So every standard proceeding case that's not expedited, we have to start the trial within 125 days. So every conviction matter that hits the hearing department calendar, that gets the same technically priority. Obviously, we use our own judgment, but it technically gets the same priority as a moral turpitude misappropriation where they're stealing thousands of dollars. So the fact that I have to set these conviction referral cases that are probably going to settle sometime down the line, that impacts my calendar. So I'm double and triple setting, hoping that these conviction cases go away. If they don't, I now have a backlog in my measure 3. So when I appreciate OCTC's perspective, and obviously I appreciate Mr. Lear and Ms. Pansky's perspective in that regard, but there is also an impact to the court system in terms of the overall effectiveness as we're prioritizing all the cases and trying to take out the bad actors and protect the public. So this low-hanging fruit that can be settled early without impacting our calendar, I think is needs to be taken a look at as well when we're looking at the data points. It's not just how many cases have settled for a private approval in the criminal conviction matters.
Okay, thank you. Does anybody else have any comments regarding factors impacting case settlement?
And Judge Wang, would you mind telling the full ad hoc commission about the ENEC experience of unrepresented attorneys versus represented attorneys and the impact of the first ENEC?
Yes, thank you, Justin. It is frustrating when, especially when we're looking at the fairness study and the Farkas report. I think all the judges are very mindful of the differences between a pro per litigant coming in at the ENEC versus litigants who have counsel. So oftentimes at the first ENEC, I am trying to go over the rules of procedure and letting them know to really look at the factors in mitigation. This practice area, I think Rachel Grunberg said it really well, is that it is a nuanced area. It's not necessarily that complicated, but it is a different animal. And so if you are a civil litigator even, or criminal litigator, it's still a different thing coming into the state bar court. And I'm very mindful of the Farkas report and the differences between outcomes between represented and not represented. So there's a natural tension with OCTC in trying to get the backlog. So they will generally not be happy with a second ENEC, but out of fairness, I think I push for a second ENEC when they're pro per litigants. Because the difference between an ENEC and a VSC is slightly different. In the ENEC, it's the early neutral evaluation. So that's an opportunity where the court can give the perspective of whether or not these charges hold. And if they hold, this is what the discipline may be, because you're entitled to and OCTC as well. They're entitled to know my perspective of whether or not the charges will hold based on the facts before them. The VSC is a little different in my view. And it's nuanced, but as the judge in the VSC, I'm the mediator. So now there's a separation of powers. I don't get as involved in terms of the evaluation portion. At that point, I am trying to negotiate and get people into meeting in the middle. So that's why it's a little bit different. And that's why the ENECs, I think, are a little bit different, and where there is a big difference in terms of what the court can do when they're pro per. I think we have a responsibility to try to eliminate any disparities at that stage. I hope that makes sense. Ruben?
Thank you, Judge Wang. I'm curious whether the, I'm going to call it a procedure primer, for lack of a better word, what you just described as that first ENEC with an unrepresented respondent. I'm curious whether that is something that is pretty uniform. Like, in other words, do you, for lack of a better word, use a checklist or a script? And if so, is that something that could be shared with every respondent upon filing of an NDC or whatever, so that maybe we'd save some time at that initial meeting?
Judge McGill can probably jump in. He's in a different project. I think he's here. I think I saw him come in. He's working with Judge Chawla, and I don't know who else is in that group. Judge McGill, do you want to jump in if you're there?
Yeah.
I don't have all the squares.
The judge is here, yes.
Yes.
Go ahead, Judge McGill.
So I think what Judge Wang is referring to, you're referring to the pro per guide, right, Judge Wang?
Right. I think that's what Ruben was asking, if
exactly.
the court was doing something, and I think you are.
Sure. Yeah. So and I think I brought this up to the Fairness Subcommittee at some point. I can't quite remember at this juncture. Maybe I don't have enough coffee this morning, but we are working on a pro per guide that includes a number of different things on how to explain to people who are representing themselves sort of things that they might not necessarily think of intuitively based on the kind of attorney work they've been doing when they come into state bar court. And this is obviously one of those areas. So we are developing, I don't know right now this is a checklist per se, but we do have a section devoted to ENECs and explaining to them what the process is. So does that answer your question, Ruben?
Yes, it does, Judge McGill. Thank you. Can I offer just an observation or a suggestion? And that is, I'm not even thinking about it in terms of a guide only for pro per respondents. I think, wow, am I still on?
Yeah.
My screen went blank. Okay. I think that every respondent, even those represented, could benefit from sort of just uniform information that's handed out to everybody or provided to everybody, because we can't all assume that defense counsel are as fabulous as Ed and Ellen here. You know what I mean? In other words, just that kind of information, if it's basic, I think it would be helpful to every respondent who shows up.
Sure. I mean, just for example, the pro per guide will probably be posted up on the website, so it'll be freely accessible to anybody who wants to see it. So it won't be just limited to people who are attorneys representing themselves. And I'm sure the defense community will review it and even probably offer suggestions for any revisions down the road.
I see Mr. Millett has his hand up.
Thank you. I just want to reinforce, I think that the pointing out the nuances in the law is very important. And that's something we also attempt to do in our letters to them, to respondents at the conclusion of our investigation. And as we move forward from pre-filing and say, you know, we're going to initiate the ENEC process, or sending them the letter where they can initiate the ENEC process, we tell them we point them to the standards. We talk about mitigation evidence and the importance of mitigation, and to begin collecting that. So we try to hit them early and often, so to speak, with that information, and for good reason, as Judge Wang pointed out.
Thanks, Steve. Ed, are you still that stuff, or are we moving over to Lisa?
Okay, thank you, everybody. And Justin, can we move on to the next bullet point?
Yeah, we can go to the next slide. Which,
here we go.
There we go. So effectiveness, we talked about prevention, support, resources, mandated trainings for attorneys. this is kind of an area, what is the State Bar doing, and should there be other focus areas where we are doing more? And the Office of Professional Competence, Randy DeFantorum gave an extensive overview of the ethics hotline and other materials that are available to all attorneys. He talked about a new effort for a self-assessment program, and that's a little bit different than some of the MCLEs that we currently offer, because the self-assessment program has the benefit of asking specific questions, and then that creates a whole data set that we can use to analyze and find out where attorneys are weak in particular areas, and maybe develop further trainings or further information. So it's a program that is going to kick off shortly. It was brought to the Board of Trustees in July, and so the self-assessment program is going to go on. We had a presentation for the Lawyer Assistance Program, which is for attorneys with substance abuse and mental health issues. There were a lot of areas that were talked about in this. I know Ed and Ellen talked about how ethics school, a lot of their clients who have taken ethics school have really benefited from it. The bar implemented a new attorney training model for 10 hours for all new attorneys, and that was based off of a lot of the ethics schools. There was talk about client trust account training, and whether or not that should be focused towards solo practitioner or small firms. So there was a lot of talk about just different areas of training. We also talked about a law practice management program. The bar used to run a law practice management program, but it was sunsetted quite a few years ago, and I believe it was for lack of use, but there was talk about maybe bringing that back. So there wasn't a working group that was developed for this area, but there were several requests by the committee for information that will be brought back to the full ad hoc commission on areas of training. And so I'm open to any questions on this. If there are any other things that members of the Effectiveness Subcommittee would like to add, or members of the commission, if there are any questions, but there wasn't a decision necessarily to make a working group on this, but to bring back progress on different areas. And then there were specific questions with regards to law practice management that we'll bring back to the full commission.
So Justin, I'd like to speak to this a little bit. And I find this topic to be one of the more interesting ones that we handled with the Effectiveness Committee. For those of you that are new or don't know Ellen and me, we are the defense attorneys, and you probably figured that out from our comments. But in our world, anytime that you can create diversion that diverts away from discipline and educates and trains the attorney, then our position would be that society benefits from that. And in that regard, the ADP, which is an acronym for Alternative Discipline Program, is a terrific program. It's probably been around for 15 years at least, and that's a program in which respondents have to qualify through what I think is a pretty rigorous process in order to show that their either mental health challenge or substance or alcohol challenge was the root cause for the misconduct in which they engaged. And in exchange for a 3-year program that they can satisfy within a year and a half, those particular respondents can get lesser discipline. And I think it's been a phenomenal success. The clients like it because 1, they're getting the help that they need through weekly peer group sessions, and 2, they're getting a break on the discipline. And it's been truly a life changer for many clients that I know personally, and that Ellen probably knows personally. The client that realizes that this is his second chance after being a cocaine addict for 15 years, that if he goes clean and sober, he won't lose his license, and he'll still be suspended, but he won't lose his license, and he'll really work hard on his rehabilitation. Ellen and I have many stories like that. And so I think that's terrific. I think it's also terrific insofar as an effort by the bar to recognize that there are life challenges that are out there that often can create aberrational misconduct. So if you have somebody that's a 20-year practitioner who's never done anything wrong and they make a mistake, then some kind of, and there's no substance or alcohol abuse issue, but to be able to train that person through ethics school, having to take the MPRE, maybe client trust accounting school where appropriate, those are things that in my experience, and I think in Ellen's experience, help prevent future misconduct for those particular respondents. And I don't recall, and Justin or somebody can remind me, I don't know exactly what the recidivism statistics were, but I'm sure that they're positive. And I think that the discussion that we should have on a future going basis is to figure out more opportunity for respondents who are admittedly recalcitrant in terms of their professional ethics to have an opportunity and to train, educate themselves, and prove that they're deserving of lesser discipline through that training, so that the public will be protected on a future going basis. So we've talked about that a little bit, and I know that in my discussion with Justin and hearing him just now, that he thinks it would be beneficial for us to have a working group on this topic as well. And so I'd encourage anybody and everybody that's not on a working group currently, and even those that are, that this is a good one. This is a good way to change the world, and to focus in on how we can do better in that regard. And I think, Cindy, do I remember correctly that this is one that you were particularly interested in, and that you had sent me an email about I think it was LA Superior Court, looking at this kind of model. Am I remembering that right or not?
No, you are correct. The LA Superior Court is having a program to have educate attorneys on, just how you go to court, what you need for court, and also focusing on lawyers of color and how we can better serve and offer services. So happy to volunteer, but yes, that was the move by LA Superior Court in a press release about a month ago.
Right, and Cindy had a really out of the box thought on this, and you and I haven't had a chance to talk about this, nor has the committee, but the out of the box thought was to somehow take our group, or at least a part of our group, and work with LASC and its working group, since we're all rowing the same way. We haven't had any further discussion on that, but I think it's worth having discussion, not necessarily right now, but let's all change the world. Ellen.
Just very briefly, my perspective as somebody who's been doing state bar defense work for well over 30 years is that a lot of the issues that we're talking about now have existed for more than 30 years. And part, I think, of the charge of this commission is to come up with a new paradigm that works better than the one that we've had in place for decades. We're basically based on a punishment type system. How we discipline lawyers, shouldn't they get more discipline? Is it going to protect the public if a lawyer gets a public reproval as opposed to a private reproval? I think that this is key, and it will also address the backlog problem. The majority of the backlog is not between the EMEC and the filing of the notice of disciplinary charges. It's at an earlier phase. The majority of the backlog, and the statistics will definitely bear this out, is in the investigative phase. And if we can build into the system more diversion in appropriate cases, obviously lawyers who engage in serious misconduct will be disciplined. And if necessary, they'll be disbarred. And nobody's suggesting that lawyers who have engaged in serious disciplinary offenses should get off lightly. That's not what anybody is promoting here. But I think to the extent that we can explore this further as a committee and look at ways in which lawyers can be better trained, better educated, not only in just what the rules are, but the care and feeding of clients. A lot of disciplinary proceedings occur because lawyers do not know how to service their clients appropriately. So this, I hope, is something that we make more of a focus as we go forward as a committee.
Thank you. Steve?
Thanks. I appreciate and value the comments about diversion and agree with them. Although I think that didn't we form a diversion working group? I thought that maybe that was a separate issue. And
that is correct, Steve. We're 2 slides ahead. We're going to get to diversion in like 2 slides to talk about that working group.
All right, so let me just address the prevention piece here, and here I will echo Ed and Ellen in spirit, if not in word, and that is I am a former criminal prosecutor. I came to the state bar. I'm a firm believer that prevention is much better than punishment in the criminal context or discipline in the state bar context. It prevents somebody from being victimized in the first place, and so the more that we can build up that scaffolding around licensees so that they don't commit misconduct in the first place, the better off we will be. So I think that the self-assessment modules that the bar has been laying groundwork for several years will be fantastic. I'm hoping that the first part of that will be the client trust accounting module, and that will be rolled out sometime next year and followed hopefully rapidly by several others. But I think that will be great. I think OCTC has been working since I got here on a solo and small firm outreach so that we are actually now on the cusp of being able to send out to any attorney who leaves government practice or a large firm and hangs a shingle, so to speak, becomes a solo or small firm practitioner. We can reach out to them with a list of ways that solo and small firm practitioners sometimes get into trouble and resources to avoid that. I think once we can do that automatically, that will be fantastic. We also have talked about for several years adopting a retirement with dignity plan. That is something that several states have an option for. I want to say it's 4 or 5, it could be more, but it's an option for permanent retirement for people who can sort of extricate themselves from the practice of law. And I have wanted to and continue to want to explore that option in California. So I think that the state bar is looking to do a lot of very proactive things to prevent misconduct. When several years ago, I used to have lunch with Zach Wexler, who was the president of the ADDC at the time, the Association of Discipline Defense Counsel, and we talked extensively about practice management, both as a term of probation and proactively having resources for practice management. And I agree with Zach, and I think I agree with Ed and Ellen that would be a tremendous boon, not only to the licensees, but also significantly to the public. And I will conclude my comment, Justin, by just saying that I believe Ms. Urshadi is here now, and I think we're going to have her introduce herself.
Thank you, Steve. You were reading my mind. Sharon, welcome and good morning. Thank you for joining us. If you wouldn't mind, would you give the commission a couple of minutes introduction about yourself and what brought you to the commission, maybe?
Yes, thank you very much for accepting me. I am an attorney from Iran. I practiced in Iran for 17 years as the in-house legal advisor to the Central Bank of Iran. So I was concentrated mostly on banking and corporations. When I came to the States in 1988, I joined a law firm a month after I had arrived. It was a minority law firm, and I worked for them for approximately 3 years, and then with 2 other attorneys. And then I decided to take the translation exam of the Department of the Judicial Council of California, and started working as a court interpreter between 1998 and 2018 for 20 years. And that's where my experience is, watching numerous attorneys work in the Superior Court. Most of the cases that I interpreted for were criminal cases, but I did a lot of family law cases as well, and some civil litigation. In 2018, after passing the age of 70, I had to retire from the Superior Court because if I didn't withdraw from my pension fund, then I would be penalized another 10%. So I decided to retire, but from then on, I worked with the Department of Justice in immigration courts. Some of the trials are held on Zoom, but recently I have been going to court in California, Los Angeles, Van Nuys, and or the downtown courthouse. I also work with the U.S. District Courts, Department of Justice, as a court interpreter. And I was very interested to join because of my background in the legal field. And of course, I come from, at the time that I started working, the adaptation of French laws, the Napoleon Code. Later in Iran, there was a revolution, as everyone knows, and Islamic laws were adopted as well. So we had 10 years after the revolution when I worked there, we had the Islamic laws, even in banking and corporations, and the French. So it was a hybrid actually system there. And later, when I came to the States, of course, the common law system and the US system, which is different. And I have observed many, many, many attorneys in court. I have observed their behavior. I have seen their misconduct. I have seen their anger, and I have seen the good side of them. So that's what brought me to this commission.
Thank you, Sharon. We're glad to have you, and we look forward to your participation.
Thank you.
Let's move on with the next slide, please, which I think takes us to another topic. And thank you, everyone, for your thoughts and your work on the prevention and support issues we were talking about. Before we move on to the next slide, actually, let me just make sure that no one on the commission has anything to add or even ask a question on those prevention and support issues. Okay, looks like not. Great, let's move on. Thank you.
Okay, so this is the topic of discipline system metrics. And the working group reviewed all the metrics that the State Bar collects. And in particular, we collect metrics for different purposes. We collect metrics that we report out to the Board of Trustees on a regular basis. We also produce an annual discipline report which is a statutory mandatory report. And we provided the working group with a list of all the metrics we collect, but we also presented the group with the list of metrics that we don't collect. And we came up with the list that we don't collect in large part because as this working group, the working groups and subcommittees have been doing their work, they've been asking for data, and then my office goes and scrambles and we find a lot of the data, but a lot of the data we didn't find. And so that, that's how we started building this list of metrics that we don't collect and that we want to explore collecting on a regular basis. And so the working group, the subcommittee, I decided that rather than forming a working group to help inform the development of a more comprehensive list of metrics that we can that we'll start reporting on a regular basis, the decision was made was to let the working groups complete their work. And then at the end of that process, we will have a very comprehensive list that we will then take to the full ad hoc commission for review and approval. So rather than forming a working group to figure that out, my office will continue our work in identifying this list of things that can be tracked further or new metrics, and then we will bring it back to the full commission in spring. Okay, so does anyone have any questions about this?
Any questions for Lisa? Okay. Thank you, Lisa.
Okay, great.
So this slide, we kind of jumped ahead a little bit where Ed gave a brief overview of the alternative discipline program, but we talked about criminal diversion programs. There were presentations on the criminal diversion programs and how they tend to be pre-conviction program. So if you if there are certain requirements and you meet all the requirements, then the case is dismissed. The alternative discipline program that the State Bar offers, there is a high and low. So you enter into a stipulation, and then if you do those certain requirements at the end, you get the low level of discipline. And if you somehow don't meet those requirements, then you get the high level of discipline. So it's not, in a sense, the true diversion that the criminal context where it's just expunged, it's done, it's dismissed. There is a level of discipline on the alternative discipline program. We also had a presentations on agreements in lieu of discipline. So there are certain levels of offenses where the Office of Chief Trial Counsel comes to an agreement. And if they meet those certain requirements, then the case is kind of dismissed. That is closer to a true diversion type program. And so we had a presentation on that. After much discussion on all of these areas, there was a decision to form a working group and on the whole area of diversion to look at the alternative discipline program, look at agreements in lieu of discipline. Could there be an expansion of that? But there was a request for data because, as Mr. Lear said, we really need the data on whether or not this helps with the recidivism rates if someone goes through the alternative discipline program. And that's where the Office of Research and Institutional Accountability, Lisa's shop, is conducting research to kind of bring that back once this working group, it was just recently formed, and later on I will be taking volunteers also for this working group as well. But that's the area of diversion that we kind of discussed with the Effectiveness Subcommittee. I don't know if anybody has anything to add.
I don't see any hands.
I don't either. And I think that concludes the Effectiveness Subcommittee update.
Good. And I was just looking at the clock. It looks like we're coming up on about an hour and a half. What do folks think about maybe a 10-minute standing break, go grab some more coffee? Everybody okay with that? It's 10:23. Let's reconvene at 10:33, please.
Okay.
Thanks. You've heard that the recording is back in progress. I hope you had a chance to replenish the resources and are ready for some more work. We are going to transition over to the Fairness Subcommittee report and discussion. And I believe the floor belongs to Ms. Buffington. Shanae, hello.
Good morning. Okay, so I was the chair of the Fairness Subcommittee, and I'm just going to give a very high-level review or recap of our discussion in our subcommittee meetings. Mr. Ure, am I going to just jump into case expungement, or are we going to cover the RA Bank matters first?
I think the first slide is just the brief background on the reports that were kind of the genesis of the Fairness Subcommittee. So I can just take that real quick. Okay. The Fairness Subcommittee received an overview of the Professor Farkas report, and the goals of the Professor Farkas report was to evaluate whether there are disparities in the discipline system. And then if there are, identify factors that contribute to those disparities. And so that was kind of the groundbreaking report that the Board of Trustees undertook. And after that report, as a result of that report, they had Professor Robertson conduct a report to analyze, and as a brief, to provide context, from 1990 to 2009 was the time period that was studied by the Farkas report. So it was a very long time period and a very extensive study. As a result of that study, Professor Robertson took that report and developed potential recommendations that the State Bar could do or implement to address those disparities in the discipline system. And so there were three main focus areas that Professor Robertson looked at, and one was reportable action in the bank cases. Attorneys with client trust accounts, if they become overdrawn, the bank notifies the state bar of that. Another area was the treatment of prior complaints. He came up with some recommendations on how the state bar could use those treatment of prior complaints, because the Farkas report showed that African-American males had a increased likelihood of had increased number of complaints as compared to their counterparts. And so that was an area of focus. And then the third area of focus from Professor Robertson was on increasing attorney representation, because as has been mentioned prior to in this meeting, attorney representation does impact outcomes. Those attorneys that had counsel had significantly better outcomes than those without counsel. And that is something that the State Bar is now starting to track as part of our metrics, expanding our metrics, is whether or not respondents are represented. So those were it was kind of an overview of those two reports, and that led to a lot of other things. And so there was no working groups per se in this area, because a lot of the things that came out of this attorney representation and metrics and stuff were developed in other areas. But it was the kind of the beginning presentation that was given to the Fairness Subcommittee. So I don't know if anybody has any questions on this one. I don't see any. So we can go. Yeah, we can go to the next slide, Lisa. And so one of the areas that Professor Robertson talked about was RA bank matters. And I don't know if Steve, can you give a high level on this?
Sure. So we had a member of OCTC come in and talk about RA bank matters. RA bank matters is really reportable actions. These are statutes that require certain parties to report things to the State Bar, in this case, banks. So we call them reportable actions banks because they're reported by banks. There's a statute that requires banks to report non-sufficient fund activities in client trust accounts. So we get notification anytime a client trust account balance drops below zero, or when if there is, for example, $5 in a client trust account and a check comes in against that client trust account for more than $5, that would also be NSF, non-sufficient fund activity. And so we review these reportable actions in intake to determine if it merits an investigation. Unlike in original matters, we actually reach out to the respondent to get sort of their side of the story, their perspective on the activity in reportable action bank matters. And frankly, a lot of these matters close in intake once we have either reviewed the non-sufficient funds activity itself or talked to the respondent. We also have a de minimis threshold below which we essentially just close the matter after some consideration of other issues, including prior non-sufficient fund activity and things like that. As Justin alluded to, Professor Robertson made some recommendations in regards to RA bank matters, including raising the de minimis threshold. Right now, I believe it's at $50, and there was some discussion of whether raising it raising it would be good if, for example, the non-sufficient funds activity was less than $50 or less than $100 under a revised standard, that essentially we say that could also be dismissed. The other recommendation was allowing attorneys to deposit their own money into client trust accounts as a cushion against non-sufficient funds activity. And we looked at those. Oriya researched the issue and determined that smaller RA bank amounts are useful predictors of subsequent discipline. So they recommended against changing the de minimis amount or depositing an attorney's own money into the client trust account. Excuse me. So we instead focused on exploring proactive, preventative approaches to prevent non-sufficient funds activity. We revised the RA bank matter letter that provides client trust accounting resources and guidance to people who about whom we've received a complaint. We revised that letter, and that letter now goes out to 800 plus lawyers a year rather than the 40 approximately who are in a certain subcategory of that. We send those letters and resources to everybody regardless. So we've increased that. We have enhanced the resources that are available. We are looking to monitor the clicks through those resources. When we send that letter out, it has links to certain resources, and we're looking to monitor whether people are actually clicking through and utilizing those resources. We revised the client trust account handbook to encourage reasonable reliance on accounting professionals and accounting technologies to support a lawyer's practice. And we also are exploring sort of turnkey banking or bookkeeping solutions as well. And so I think the decision was to monitor the impact of these approaches before forming any specific working group on RA bank matters.
Thank you, Steve. And that was the decision. It was kind of to monitor to see how the new expansion of the letter with the resources provided, because there was extensive discussion on those increasing the de minimis standard or allowing a cushion, but there was no action taken by the subcommittee at this time. Are there any questions on this?
Janet has her hand raised. Ms. King?
Yeah, I'm not seeing Janet on my screen at least.
Oh, that's interesting. Let me just see. Oh, yeah, I'm sorry. She is in the attendee.
She's raising her hand to be let in.
Yes.
Okay.
Once we let her in, maybe she'll have something to say.
Yeah, I just.
But no pressure.
Okay, she should be in.
She's
now.
gonna.
Okay.
Okay. Does anyone have any questions or comments on what Steve just presented?
All right.
Janet, please. You're on mute.
Janet, did you have something to say?
Yes, sorry. Are there transaction coordinators that work with sole proprietor attorneys? In real estate, for example, we pay, it's a nominal fee, literally $500 to $700 for once we enter escrow, that they keep us legally correct using the contracts, getting the signatures. Minor fee. Is there a transaction coordinator for a sole proprietor in the legal firm or legal field?
That's an excellent question.
I'm assuming that question is for me, and I believe the answer is no, that's not something that has been encouraged previously. It's always been stated that client trust accounting is a non-delegable duty. That doesn't mean that somebody else can't be involved, but ultimately that the attorney has the ultimate responsibility for the outcome. And we have revised the client trust accounting, and we are exploring other options. That's part of that, for allowing somebody else to sort of maintain that account. Of course, the attorney is still going to be responsible for, in the end, what happens, but we're trying to not discourage them from consulting professionals, whether that be a transaction monitor or something else. I don't know if that answers your question.
I think, Steve, it answers the question, at least as I perceive the question, but the fact of the question being asked, I think, is an important, for me at least, a pause, right? It's my dogs are fighting, I apologize. It's this notion that, there are other industries where, large sums of money and transactions in the thousands, or if not the millions across the state are happening every day. And there are other ways to look at safeguarding funds, in an escrow account or otherwise. And so I appreciate Janet's perspective on that, and can tell you that there, I've been a part of discussions where we're asking those very same questions. So If any other commission members have any other examples from other industries, I'd be more than happy to, I'd love to hear them actually, or your thoughts on the notion. Of course, you know, we do have statutory restrictions and regulations that we need to be cognizant of, but it doesn't mean we couldn't propose changes to the legislature where appropriate. Any thoughts, folks? Okay, let's move on to the next topic, please.
Okay. And the next topic, I believe, is expungement,
Yes.
case expungement. And
Yes, so once again, our subcommittee had discussed expungement, record retention, record deletion, and as well as archiving of complaints. And from my understanding, OCTC archives complaints after 5 years, which are only accessible upon request to upper level management for a bona fide reason. And maybe Mr. Mowat can kind of flesh out or can speak to more on the accessibility standard. One of our subcommittee members, Mr. Larkin, had provided information on practices employed in Illinois. Specifically, Mr. Larkin had stated that, or from my understanding, 3 years after date of dismissal, a record is eliminated. Then the Fairness Subcommittee had discussion on what the expungement process would entail if implemented, and our very own Ray Buenaventura had presented on how expungement works in the criminal justice system. Specifically, he spoke to when expungement may be sought after a conviction and mitigating factors considered during the expungement process. Then there was follow-up discussion on what type of discipline would be eligible for expungement. How long after discipline is imposed would one be eligible to apply for expungement, mitigating factors to be considered, how prior complaints would affect expungement, and how expungement would impact consumer alerts on the State Bar's website. Our committee then discussed the possibility of developing a proactive non-disciplinary system to support attorneys who have a higher risk of receiving complaints. I don't think we discussed how these persons would be identified. So as a result of our discussion on expungement, a working group was formed, a meeting was held to explore these issues and concerns, and maybe we can have either Ms. Sarah Good or Ray Buenaventura kind of give us an update of exactly what was discussed in that working group meeting on case expungement.
And I can jump in here for Sarah. So we did talk about the expungement in the criminal context, and we talked about administrative expungement. We currently at the State Bar have a process for administrative expungement if you didn't pay your fees on time or you didn't do your MCLE on time, and it's kind of automatic. And so if you meet these certain criterias, the suspension was less than 90 days, it automatically happens. And so we were looking at you can petition currently the Supreme Court for expungement. And we looked and researched, and I think it had happened twice and both were denied, but there's not really a process to petition the Supreme Court on expungement. So the working group is going to maybe look at that and how that would be developed further. Are there certain types of cases that could be eligible for expungement? And are there other criteria that would need to be met? But a lot of the focus of the subcommittee was on what is on the website. The State Bar really has two distinct websites. There's the State Bar Court website that is the record of all the case. It's the record of the case. And then there's the attorney profile page, which is kind of when you go and look up your attorneys online, that's the page you go to. If you Google someone's name, it mostly goes to the attorney profile page. And as you've heard from most of the people, when any discipline happens, it's on there forever. It never goes away. It's always on there. And so that's where the expungement working group is going to look at, is there a level of offense that could be potentially expunged after a certain number of years? Because we did get public comment from an attorney who had a public reproval. And after 12 years at their job, they were seeking other employment. And this public reproval was, 15 years ago, and they were finding it very difficult to find new employment because this public reproval, that 15 years where they haven't had any subsequent discipline whatsoever, and it's still on the website and makes it very hard. And there are instances, I think Steve mentioned or Ed mentioned, where there is private reprovals that are public. So the ultimate discipline is private, but the notice of disciplinary charges have already gone, or it's a C case, and that discipline that would normally be private is public. So those are the areas where I think the working group is going to focus on. Is there a way, and also, is it going to be a petition based, or is it going to be automatic? So will it just automatically fall off if a certain number of things are hit, or is it something that they're going to actively have to petition? And if you do the actively petitioning route, that's a whole resource issue, and we have to kind of look at all of those different things. So Sarah has her hand raised, so I will turn it over to Sarah.
Thanks, Justin. That was great. You were really comprehensive, and you saved me from being put on the spot there by Shanae. I just wanted to add that we had a lot of discussions. Really the point of the discussion is how to remediate for all of the folks, primarily Black men, who have been disproportionately sanctioned and disciplined by the bar in the past, and how to kind of remediate that to permit people to excise that and move forward with their careers. And so we're looking at, as Justin mentioned, automatic expungement after umpteen years, as is done in the criminal justice system for certain things. And then for other kinds of offenses, there might be some sort of a petition process. But obviously the Supreme Court route, is never taken and not really a viable process for people. So we had some discussion around, can we break down how we look at it by offense? And I think it was Mr. Moad who pointed out that that was going to be difficult, and we might want to look at what kind of the penalty was, what the outcome was, and then the outcome would kind of drive expungement, or what that would look like, and whether it would be automatic or discretionary. So just wanted to kind of chime in there on that. And I think that's where we left it. So lots of work to do. Thanks.
Thank you, Ms. Good. That was a good summary and bringing up those topics. Is there any other questions about expungement? Linda
Schneider.
Thank you. I just wanted to offer for the working group that is working on expungement another resource to take a look at. The Contractors State License Board has a legislative provision, Business and Professions Code section 7124.6, that has a pretty comprehensive way of looking at their discipline and what is subject to public disclosure and for what period of time. So I wanted to point out that code section because in my experience, it's one of the more comprehensive provisions under the law that allows for this kind of disclosure that this committee is looking at. Thank you.
Thank you, Linda. Any other questions or comments on expungement? Then I think we're going to move on to progressive discipline. Is that correct, Justin?
Yes.
Okay. Take it away.
And we had Mr. Carlucci, I think, gave from the Office of Chief Trial Counsel, gave a presentation on progressive discipline and how that impacts future discipline. This is where it kind of crossed over with the Effectiveness Subcommittee, where they talked about judicial discretion on the prior discipline. And so I don't know, Steve, if you want to talk, give a little bit better overview of progressive discipline than I.
Sure. I'm assuming that everyone is sick of listening to me at this point, but I will note for the record that Justin is calling on me, so I'll talk a little bit about progressive discipline. So progressive discipline really means that with limited exceptions, an attorney with a prior record of discipline will receive greater discipline for their second imposition of discipline than they did for their first, and so on. In certain circumstances and with specific exceptions, the presumptive level of discipline for an attorney's third imposition of discipline is disbarment. It doesn't mean it always happens. It just means that that is the presumed sanction. Progressive discipline is found in Standard 1.8 of the Standards for Attorney Sanctions for Professional Misconduct. It is also built in a limited circumstance to Standard 8.0 of the American Bar Association's Standards for Imposing Lawyer Sanctions. The rationale for progressive discipline is based on the long-held disciplinary principle that a prior record of discipline is a significant aggravating factor in determining the appropriate degree of discipline, the appropriate level of discipline. And for that principle, we rely on Supreme Court precedent, which says really three things. The first is that the degree of discipline imposed must be sufficient to deter future wrongdoing by the licensee. So that's the main point of the level of discipline. And then the Supreme Court goes on to hold in separate cases that the commission of misconduct after discipline has been imposed is strong evidence that the attorney is unwilling or unable to conform their conduct to their ethical obligations, and therefore they present a risk of future misconduct and harm to the public, the clients, and the administration of justice. And the Supreme Court went on in a separate case and held that subsequent misconduct demonstrates that the prior discipline was inadequate and that a higher level of discipline than previously imposed is necessary to deter future misconduct and to fulfill the primary purposes of discipline. Now, that doesn't mean that that's always true. That's just sort of the starting point. And certainly there are aggravating and mitigating factors and other things that the court considers in determining what the appropriate level of discipline is. And a number of those are set out in the standard. We also surveyed other jurisdictions, and 19 other jurisdictions responded. 2 of those other jurisdictions require progressive discipline. 15 of them replied that while it's not required, their case law generally results in progressive discipline as a matter of practice. And only 2 said they do not necessarily impose progressive discipline, 2 other jurisdictions. So that's sort of the summary of it, and it certainly is a fertile ground for a working group.
Thank you, Steve. Normally Melanie's here, and so I can split it up between you two. So I apologize for picking on you today, but you have one more after this. So that's kind of the idea on progressive discipline. I think that this was an area where both subcommittees expressed that there should be a working group. And so I will be taking volunteers once we get to the working group part of the program, which is at the very end after this presentation. So if there are any other questions are there any other questions on this? Seeing none, I think we can go to the next slide, Lisa. The perception of state bar court independence. I apologize for that misprint. Judge McGill, would you mind providing an overview of this topic?
Sure, Justin, thank you very much. So back in July, I presented state bar court concerns regarding perceptions of the court's impartiality from attorneys who are in the discipline system and also members of the public, and also provided some anecdotal examples of how those pop up in our cases from time to time. And then I also offered up 3 proposals that the judges would like to have considered. And at the conclusion of it, Leah and Sean suggested that the discussion on this topic take place directly between the state bar court judges and bar leadership. And since that time in July, Leah and the presiding judge, Judge Purcell, and I have continued to work on this. And at this point, we do have some results to share with the commission at this time. So the three issues that the judges thought would promote the court's impartiality, not only just the perception of it, but also the actual impartiality, would be to discontinue the court's use of the state bar seal in courtrooms and on official documents. The second one was to change the court staff email designations from @calbar.ca.gov to @statebarcourt.ca.gov, which is the same email designations that the court uses. Currently, the staff's designation is what all staff at the state bar utilizes. And then finally, to obtain a separate budget for judges to use outside counsel instead of relying on the Office of General Counsel for representation and legal advice. Because at times, OGC is representing and working with OCTC in regarding disciplinary proceedings that take place before us. So first of all, regarding the seal and the staff mail email addresses, sorry, stumbled over that. Leah and Judge Purcell had additional discussions, and it has been agreed that the state bar seal in the courtrooms will be taken down, and the court will have its own separate seal placed in state bar court courtrooms and also on official documents. Leah has obtained the services of a graphics designer to work with the judges to create the new seal. And also the court staff will have email addresses using the state bar court email designation, the same as that the judges use. The judges would like to thank Leah. I don't know if she's still here. I think she left to go to another meeting, but we do want to thank Leah for listening to our concerns on those 2 points and taking quick action to resolve it. As for the third issue, the separate budget, that of course is a bit more complicated, the most complicated of the three. And Leah and we judges have exchanged information to more fully understand the scope and the history of the issue. This goes back actually, this discussion's been going on in one form or another since as early as 1994, about 5 years after the court was formed. And we continue to work on it. And it's something that I think we'll have some positive outcome down the road, but because it's complicated, it'll take a little bit longer. So I think those are the three things. Not really something for the ad hoc commission to work on, but Justin and I thought it was important that the commission get a full understanding of what happened after the presentation in July. So Justin, I turn it back over to you.
Thank you, Judge Miguel. And it was, yeah, we're just giving a complete overview of what was discussed in fairness because the perception does impact fairness.
Yes.
Are there any questions? I don't see any, and I don't mean to take this away from you, Shanae. I think we can.
I'm up next. Okay. So the subcommittee discussed the possible impact on recidivism if respondents are informed of complaints that are dismissed or closed without action. We discussed that informing respondents of such complaints may put the respondent on notice of possible mismanagement practices or oversights, mistakes, errors in practice management, which may in turn encourage corrective action or being proactive in steering away from possible future discipline. I believe we discussed how this notice, though, would then impose reporting requirements on attorneys. There was also discussion that such notice would require disclosure to different entities as well. I think we had discussed, and maybe Ms. Pansky can kind of chime in, but I believe we discussed that, you know, if we inform respondents that, you know, a complaint had been filed, but it was found to be unsubstantiated, if that attorney then subsequently applies for licensure in a different state, that attorney would then have to disclose that a complaint had been initiated or closed. We've received information that 13 jurisdictions currently provide correspondence when complaints are closed without action, Illinois being one of them. But one overarching issue that was discussed was the impact on OCTC resources, specifically staff time and office resources to generate notices. Of course, it was discussed if such notice would in fact impact recidivism. Our subcommittee then discussed mandatory or compulsory MTLE of law practice management at various stages in the discipline process, or if a complaint was initiated and thereafter closed. Our working group was formed of Jerry Larkin, Ed Lear, and Steve Moet. And I believe that's all I have for this recap. Are there any questions? Oh, Ms. Pansky.
Thank you. Thank you so much. I was just going to add one small comment, and that is one of the considerations regarding advising respondents that that the State Bar received a complaint that was closed without the need to contact the respondent is that in California, unlike some other states, investigations are entirely confidential and they're not revealed to anyone, including a public member who wants to call in and find out, has a complaint ever been made against this lawyer? If the complaint was closed with no action, the member of the public is not advised. So one consideration about advising the lawyer is whether that's going to open up confidentiality. And on balance, I think the respondent's bar position would be, it's better that groundless complaints that were determined to have no merit be kept confidential for all purposes. If the trade-off is, if you're going to tell the lawyer that this groundless complaint was closed because it didn't present even an issue of a disciplinary offense, then that should also be told to the public. So that would be the respondent's perspective, at least as far as I'm concerned.
Thank you, Ms. Pansky.
Yeah, I following up, this was a lengthy discussion that I think the whole subcommittee talked about, the balance between the work that will be generated with OCTC if they did notify. We get 18,000 complaints a year or something around that. And so to send out an automatic letter is one thing, but all the work that is generated once the attorney gets that letter and is calling the State Bar and is inquiring about this complaint and following up. But there also has been other states, unfortunately, Jerry's under the weather today. He's commented that it's been positively implemented in Illinois, notifying the attorneys. And there has been some data that it is a little bit indicative if you have a lot of complaints. Now, the working group has been formed and we haven't met yet. And I will be taking solicitations for members for that working group in a little bit, but I see Steve has his hand up.
Thank you. Yeah, I just wanted to reiterate, I guess, and agree that really what we're talking about when we talk about those other states that have successfully implemented this is it is a matter of scale. And we have a much larger number of complaints that we receive each year than really any other state. I mean, the next closest state to us is nowhere near us. And as far as the number of lawyers, the size of our discipline system, the number of complaints that we receive. And as Ms. Buffington said, there is some question as to the effectiveness of telling the lawyer that we have closed a complaint because we found it to be meritless or baseless or whatever. In some circumstances, it may be valuable to reach out and say, hey, look, we've gotten a number of these complaints, and maybe if you were better about communicating with your clients, you could avoid some of these complaints in the future, something along those lines. But I'm not sure that it makes sense to open up, as Justin said, to send that one letter. If we could automate it, that's not that big of a deal, but it's the flood of phone calls and mail that we would then expect to receive from that lawyer who, even though we have closed that case as lacking merit, wants to file a rebuttal to the complaint or say that the client doesn't know what they're talking about or whatever else. And it's that piece that we feel would really pull our resources. It would also be a very huge change to our practice. As well as, and I want to recognize what Ms. Pansky said about the potential, confidentiality concerns. I don't know how exactly that would be resolved, but I would tend to agree that that is one concern that was voiced by ADDC. And I think another that was mentioned was that even if it is closed without merit, and frankly, when somebody goes to apply to another jurisdiction, I think they're entitled to complaints that are closed anyway, that other jurisdiction, in evaluating their membership in that other jurisdiction. But there was also something I think we discussed about insurance, malpractice insurance, and that may have to be disclosed there, as well as potentially to other jobs. And so
With fries?
So that's
okay,
also
thank you.
I see Janet's hands up as well as Linda's. Janet, go ahead.
Yes, it seems that, is there any other level of a complaint where it's not going to induce higher costs, yet be more preventative? It's the similar thought process when you see a police officer drive by, it reminds you to watch your speed limit and to be careful. And if we're talking about a preventative measure, I understand the complaint is a whole different level, but if an attorney is getting some notice that there's been comments or a call through an email and not a written material, it might be save money in the long run. Just a thought.
Thanks, Janet. Linda?
I just wanted to point out that the legislature has addressed this similar issue in the context of healing arts in Business and Professions Code Section 800. So that's one that the working group might want to take a look at to see if there's other ways to go on this issue that might be helpful in reaching solutions. Thank you.
It's a good suggestion. Thank you. Any other questions or comments on this topic? Okay, seeing none, we will move to the next one, which is attorney's fees and costs. Is that right?
Yes, and this is one that I will talk about. The Fairness Subcommittee had a presentation on the state bar discipline fees. We sent out a survey to other states to see a comparison of our fees with other states' fees. And the state bar fees were significantly higher than those of other states that responded to the survey. Granted, it was only 16 states that responded to the survey, but they were significantly higher. The state bar assesses costs for the discipline system based off a 2010 workload study. It does not include attorneys in that cost, but it includes all the administrative support and all the other things that go into prosecuting a case. When you hear the ADDC talk about costs and their impacts on their clients, they escalate quickly. And the sooner you settle a case in the process, the cheaper it is. If you settle, prior to filing a notice of disciplinary charges, it's like $3,500. Whereas if you go to a multi-day trial that goes to the review department, it's somewhere in the neighborhood of $23,000. So you can see all along the way that it gets significantly higher. Now, these costs can be spread over several years. They're paid annually with the licensing fees, and you can petition the court, and we couldn't quite get to that. We're still trying to find that data in the system, but anecdotally, both judges said that it is routinely granted where they can spread those costs over several years to repay, but they're still significant. It's still $23,000 if you go that way. And so there was also a presentation on sanctions. There is a business professions code where the state bar can issue sanctions. The Supreme Court recently, as of, I think it was last year, provided guidance on rules on how to do the sanctions, and it's up to $5,000 per allegation with an up to $50,000 max. And so those are in addition to the court costs. And the Fairness Subcommittee had presentation on court costs in general in the criminal context, and how there tends to be a shift away from doing all of these different charges. California passed historic legislation, the first in the nation, to eliminate a lot of these fees. I think it's 23 fees for that are associated with like the criminal court costs. So your ankle monitoring fee or the pretrial investigation report, all of these fees that used to be charged to people have been eliminated. And so that the state bar still has these extensive costs, and now just recently implemented sanctions seems to counter the what is going on in other areas of the courts. So the decision was made to take a look at this and see, maybe evaluate the model with which we administer costs, and also take a look at the sanctions themselves. And so we formed a working group and haven't met because we just recently formed this working group, and I will be soliciting extra members at the end of the presentation today. But that's the update on the court costs. I don't know if there are any questions. I don't see any.
Nope. Okay.
All right.
I believe Shanae is on the next.
Yes.
Topic.
Okay, I don't have much to discuss here, but our subcommittee had discussed OCTC's current method of communicating with complaining witnesses, which is done both in writing and over the phone. It was suggested by one subcommittee member that in an effort to build a more personal rapport, trust in the complaint process, fairness, transparency, that OCTC staff should communicate with CWs more over the phone. This in turn prompted a discussion on impact on resources and staff time. No recommendation resulted from this discussion. Any question? None? Okay.
Okay.
Respondent representation. So our subcommittee discussed the impact on discipline outcome and respondent representation. We've received information on attorney economic pressures, cost to retain counsel, cost to go through the discipline process, costs associated with ADP and LAP. As we all know, as discipline action progresses, so does the estimated cost of representation. I believe, for instance, we received information that a cost for a trial or a hearing is between $15,000 and $20,000. The subcommittee also discussed the correlation between lack of access of financial resources and the ability to secure representation in discipline proceedings, which of course turned upon the discussion of access to justice and the disproportionate impact upon certain racial groups. Professor Robertson had presented information that Blacks generally have less economic power, and he presented an equation, the same professionalism plus different wealth equals different discipline outcome. It was also, Professor Robertson also presented that Black males are less likely to be represented in discipline matters. There was discussion of forming a pro bono attorney panel or a program similar to the Public Defender's Office for members facing discipline action that meets certain income eligibility levels. But I believe in this context, we had discussed professional liability insurance, and maybe Mr. Lear or Ms. Pansky can discuss this further as it relates to ADDC. There was discussion of expanding an appointed counsel program, which currently provides representation to persons with capacity issues, to indigent attorneys who are facing discipline matters. But the idea was kind of pitched to have a pilot program first to see how it runs and receive some feedback and data from that pilot program. And I think that's all I have for respondent representation. I don't know, Mr. Mayor, can you kind of chime in on the professional liability insurance as it relates to attorneys providing either pro bono or pro bono counsel to persons who are facing discipline matters?
Sure.
Thank you.
We have currently, as a group, we have an issue with how the what are called TT cases are being handled or parceled out. And that is to say, those are confidential proceedings where the court has a concern that the respondent is not able to represent him or herself competently. And there are those of us out of the defense bar that volunteer to be on a list and to handle those matters at what I'll call low bono. The low bono was probably in the neighborhood of $125 to $150 before, and has been increased to $300 an hour, which is pretty significantly below the rates of most of the defense counsel. That said, the issue that we have is that we are not provided professional liability protection on those cases or indemnification. And there's at least one notable case of one of our members where he was sued along with everybody else, including the court and the prosecutor and whatnot. And he had to tender that to his own insurer and pay a $5,000 payment towards the insurance policy. And that's an amount that was not reimbursed by the bar. It's something that I've made many at the bar aware of. And I think as a response to that, the what we'll call the low bono has been raised from that $125, $150 up to $300 an hour in order to compensate us for that. That still doesn't really cover it. And the concern out of the ADDC group generally is that we are in a position where we are much, much, much more likely to be sued by a respondent in that context because of the type of respondents that are not competent to represent themselves in a state bar court proceeding. They are, let's just leave it at that. And so I'm giving you that bit of background because it's an ongoing issue, and we're continuing to hope that the bar steps up and indemnifies us if they expect us to do TT cases, which we are willing to do. And it's something that our group looks at as a way of giving back, because we're certainly not making what we would otherwise make. The issue of handling low bono, pro bono in a non-TT context is something that we've discussed on our listserv. It's something that we are, as a group, very much in favor of doing, insofar as making sure that respondents who are not otherwise able to afford counsel are afforded an opportunity to have counsel in a state bar context. We would, I don't know that the professional liability issue comes into play in the same way there. I think we all should, or most of us do, have professional liability insurance. I think the issue there is a different one. The issue is not wanting to do work for $300 an hour if a respondent is making $150,000 a year. It's we feel like we'd be taken advantage of in that context. So one of the things that we've talked about, and I've talked to Professor Robertson about, is that we would need some mechanism wherein there would be proof that the attorney truly cannot afford legal fees. And at that point, we would consider that, not even consider it. I think we'd enthusiastically jump in and provide representation. And I have not drilled down into the weeds on this with the ADDC and even with Professor Robertson. I think just personally, if an attorney is making $50,000 or less, that sounds like a situation where we would consider at least a low bono. And there are attorneys out there that are making $50,000 or less, but certainly our the hesitation we would have as a group is being taken advantage of. Ellen, what do you think?
I agree with everything you've said. It's my understanding that ADDC is working directly with OCTC and the court to try to come up with a defined program. And my understanding is that that's moving forward.
Actually, Professor Robertson's kind of taking the lead on this and working with ADDC leadership to outline like what a pilot program to start off with would look like. And we've also discussed the means tested mechanism would be for attorneys who pay reduced licensing fees. I believe that it's $60,000 a year. So that's something then that we're exploring, because that's something that's easy to check, because the State Bar, we have those records. So that work is ongoing.
Thank you. Anyone have any other questions or comments on this topic? Okay, appreciate the input, everyone. Let's move on to the next slide, please. I think this may be the transitionary point. Is that correct, Justin?
That is correct.
All right. I'm going to hand it to you.
Thank you, Shanae, for getting us through fairness. I appreciate it. And to wrap it up, the updates on that progress that Ellen was talking about and that Lisa was talking about will be brought to the full ad hoc commission. There wasn't a working group established, but we will bring updates to the full commission. Now I would like to shift to the working groups themselves. We did actually kind of talk about what the working groups are currently doing, so I'm not going to repeat that. So this will probably go quicker than I had anticipated originally, but if we could go to the first working group. We spoke about the ENEC working group. It's met the most of any of the working groups yet. It has a regular meeting. It's those are the working group members. There's a lot of data that is required for this. And so we're looking at the outcomes with the ENECs. And since it's a confidential process, getting that data is not always easy. And so we are in the process of doing that. I don't have too much. We kind of already talked about this, so I don't have anything more to add unless anybody else would like to add something to it, or if there are any questions on it, we can go to the next one.
Well, I'm sorry, Justin, did you want to solicit more members for this, or are you going to ask it at the end? Like,
this one has met a lot, so I'm okay with the number of members on this one.
Okay.
I will be asking after this next one.
Okay.
I will start to ask for members.
Okay, great.
And then we actually have to form a new one. The other working group that has met out of fairness was the moral turpitude working group, and it has the 3 members. They've had one meeting. We're going to schedule another one soon. It's on the data gathering, and I think Steve gave an extensive overview of what they've talked about and what the data said in the initial meeting. And so we're going to continue this one. If there are no questions on this one, since we've kind of already discussed it, I would go to the next one. The diversion working group. So this is the working group that's going to look at the recidivism rates for those that participate in ADP, can look at the agreements in lieu and discipline and warning letters, like a true diversion. When we opened this working group up, I think Karen volunteered because she was very nice to do it, and Steve and Ellen volunteered. But this working group, if there are other members of the committee that would like to participate in this working group, I would welcome them. Not everyone is required to be on a working group, but if you aren't on a working group, I would recommend it, because this is where a majority of the work is going to be, and it would be nice to kind of help the others shoulder the blame, or not shoulder the blame, but shoulder the work, because I know we're relying heavily on ADDC and OCTC and State Bar Court particularly. So if there are any other members here, and if you decide, at lunch today that you want to join this, you can feel free to email me. So these aren't closed off by any stretch of the imagination. So if you don't want to volunteer now, you want to think about where your focus is, where your interest is, then feel free to email me later. But I will always take volunteers now if there's anybody that wants to be added to the diversion working group. Shanae?
Alexia as well.
Okay.
Thank you both.
Yes, thank you. Michelle, you as well? Okay. Thank you. Okay, if we go to the next working group. The expungement working group, we've met once. It has a really good number of members. I think I anticipate meeting in early October with this one again. This one has kind of two main areas of interest: the expungement process itself, and then also what is on the website. We might have more ability to change things as to what's on the website and how long it's on the website versus the expungement process might be a little more difficult and require rule and statute changes. But this working group has met. I think it's a really good size. If anybody has a particular interest, feel free to join, and I can bring them up to speed, or they can rewatch the first working group meeting. I will add, because I know some people miss meetings, all of these meetings are on our website. So if you can't find it, you can email me and I'll direct you to it. But every single one of our ad hoc working groups, subcommissions, or full ad hoc commission meetings are on the website for future viewing. I don't see anybody that is raising their hand now, and this working group seems to be a good size, so I will go to the next working group. Discipline costs working group. I recently explained this, so I'm not going to go into detail again. I think that there's a real opportunity here to bring these costs in line with other states or make them a little bit more reasonable. So are there any volunteers to join this working group?
Justin, will you please add me to that group?
Yes.
Thanks.
Justin, this is Sean Saleg. I'll join this group.
Okay. Thank you both. That gets us up. Okay, we can go to the next working group. This working group is to discuss the issue that we've talked about, the balance between informing an attorney if they have multiple complaints closed with no discipline versus workload. We have 4 members currently on this working group. It was just recently formed. It hasn't met yet. Is there anyone on this commission that would like to join this working group? I see Sarah's hand. Thank you, Sarah. Okay. We can go to the next working group, and this is the Progressive Discipline Working Group. This is where there's not a working group, but there has been interest in both sides because both Effectiveness and Fairness had talked about the progressive working group, the potential creation of a progressive working group, and whether or not discipline, how that is handled, and increased judicial discretion potential, and how that could be handled. So I am taking volunteers for this working group, and I see Steve volunteering, and I see Judge Wang volunteering, and I see Ray volunteering, and I see Martin and Sarah. Steve.
Well, Justin's counting up the raised hands. How many of you had a flashback to being a kid and watching? Oh my goodness, I can't remember the name of the show. I see you and I see you. Cool stuff.
Romper Room.
Yeah, something like that. Yeah, I'm showing my age, but yes, it might have been it.
So I have Sarah, Eloise, and Shalon. Okay. And Martin and Judge Wang and Steve. Okay. That's great. And I think, is that the end of the presentation, Lisa?
It is, as I see it at least.
Okay.
Great. Let me go back to our full agenda. that was the last item on our agenda. We don't have any closed session. I just want to take the prerogative of the chair for a second to point out that, first of all, great that we have been very efficient this morning, and we'll get at least an hour back to our afternoon. But I think that one of the takeaways for me from these reports and the conversation we've been having is there's a lot of work going on in many, many different areas on this commission. And certainly it's very obvious to me that many of you have devoted substantial amounts of time to the work at the subcommittees and the working groups, and I very much appreciate it. You're doing, I think, a very good service to the profession and to the public. And so I just, on behalf of the Board of Trustees and our staff, I want to thank you for what you're doing. I understand you're all volunteers and you all have very busy lives, so it doesn't go unnoticed on my part. And I certainly encourage everyone to continue, because I feel like we're hitting our stride, and the next several months going into the beginning of the year are going to be important for the commission and on our way to the Board of Trustees with whatever recommendations we ultimately come up with. So thank you. Does anybody have any questions or comments in closing before we move on to the rest of our days? Justin, thank you very much for your staff work on this. You've done a great job today. Appreciate it. Okay.
Thank you.
We'll see you soon. Take care.
Thanks, everybody.
Thank you,
Bye-bye.
everyone.